So you decided to drink. You took the extra step of driving again when you had three of these. They should have charged you with a felony. I don't know why these departments are not doing it. I don't know. They should be. The law says 3 in your life. You've had 4 in 10 years. Even under the old law, this was a felony. Now, I can't remember how long the new law has been in effect. When they change it, I black it out. I take it out of my mind. But it's been at least 15 years. Michael Edward Patrick, 26W8428738.
Michael A. Carmen, B73824, I'm happy to defend it, Your Honor.
Your name?
Michael Patrick, Your Honor.
So I just want to be upfront with everybody. I'm totally in favor of accepting him into sobriety. But this is your 4th drunk driving in 10 years. You had him at 16, 19, 21, and 26. So the likelihood of you not going to jail today, Mr. Patrick, is next to nothing. I just want you to know that. Before we go on, have you had a chance to review the report with him, and are there any material additions, corrections, or deletions?
Your Honor, yes, I have. No, I don't believe so at all. Factually accurate. My big thing was with this, my client lost his wife of 36 years about coming up on almost exactly 1 year ago, and had a really hard time, dealing with that and, relapsed unfortunately, but he says he's been in the, I guess it's called bond phase for a month and has been doing great, really just trying to attack his issues, which he doesn't deny head on. I think he's a perfect Supreme Court candidate. I really do. He does have some priors, but he's got three sons that he's married to adulthood. He realizes that this has been a problem, but I think his relapse is understandable. Suddenly losing his wife at 59 years old, so I would just ask the court to take that into account. I'll let him say anything else he'd like to.
Sir, what would you like to say?
I'd just like to say, Your Honor, that mistake that I made drinking was on Mother's Day. I just had a really hard time with this, and I made a super bad choice. I didn't drink. I haven't drank since my last one. Not one drop of it. I was totally alcohol free until Mother's Day. Your Honor. I've lost like 50 pounds, this year. I'm ashamed of myself. I'm sure my wife's probably looking down on me right now and not very happy with me. It kind of obsessed me. I just like the opportunity to show that I can do the sobriety board and do it all to the end. I could do it.
And you're just to emphasize what's in the reports. I'm sure you reviewed. You've been testing twice weekly for chemical and alcohol, all negative tests, and no sober link device violations, and all blows being timely, and not a single reading for alcohol. So in over almost 5 weeks.
This is a tough one. The last thing I want to do is cause somebody to go backwards in their recovery, and it seems as though it's done really well. But let's take everything that you said at face value. Let's say you were having a hard time. I believe you.
Still having a hard time, Your Honor.
So you decided to drink. You took the extra step of driving again when you had three of these. They should have charged you with a felony. I don't know why these departments are not doing it. I don't know. They should be. The law says 3 in your life. You've had 4 in 10 years. Even under the old law, this was a felony. Now, I can't remember how long the new law has been in effect. When they change it, I black it out. I take it out of my mind, but it's been at least 15 years. 2 years probation. I'll be happy to accept you in the sobriety court. You cannot leave the state without consent of the court. You cannot violate any law or ordinance. Change your address, place of employment, home telephone number. You must notify probation. You have to report as directed. You're to comply with all agreements, guidelines, and requirements as indicated in the sobriety court participant handbook. No alcohol, no marijuana, no illegal drugs. You're not to purchase, possess, or consume any one of those. You're to submit to chemical testing, PBTs, and ETGs on demand of me and or the probation department. Pay all costs associated therewith. You're to submit to chemical testing, PBTs, and ETGs on demand of probation. You're to complete 60 additional days on the sober life device. After completion of your jail term, you're to attend AA 3 times a week and provide written proof of attendance. You're to obtain an AA/NA sponsor. You're to attend all substance abuse treatment at a facility approved by probation and would provide written proof of attendance. You're to attend the Victims Impact Panel. You're to attend and complete the Armed Specialty Court Weekend Program. You're to report to sobriety court status review hearings with me every 2 weeks. You'll meet with probation in the off week. You're to obtain and maintain employment with food provided. Actually, you're completely retired, right? So I'm not gonna require that. Not to require that. You're retired at 59 or 60 now. You're to pay fines in the amount of 200, costs in the amount of 300. $75 victims' rights fee, $50 justice assessment, and a $60 screening fee. So that totals $685. You're to pay probation fees of $480. That brings your total to $1165. You have $360 in sobriety court fees, bringing your total to $1525. You also have, this was a breathalyzer, right?
Yes, sir.
$150 in cost of recovery. So your total $1675. I'm gonna order. I'm gonna order 24 days jail. I'm gonna give you
I'm sorry, Nick, I'm talking.
24 days jail. I'm gonna give you credit for one. I'm gonna allow you to serve 6 on the court work program. There's a $35 a day charge for that, for a total of $210. So your total fines and costs amount to $1,885. You're gonna serve 17 days now. Jail. It's a gift. It's only because you've done so well. 4th offense, I can't live with. I'll cut it down like you'd have done 90 here, 65, 75, whatever, close to 90. Under this charge. Had they enhanced and gone with a felony, which they should have, you'd have served a lot more. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal, so you are in custody.
Your Honor, can he have a day or two to get his affairs in order before he reports?
I'm sorry.
My house is open. I have nobody to help or to square the things at home.
You need a couple hours, I'll let you go. But you're coming back here by 1 o'clock.
Sir.
Do you understand?
Yes, sir.
Can't expect to keep doing this without severe consequences. Like I said, there is no way. I'll just say this, jail term to begin at 1 p.m. Don't make me send the police out for you. Okay? And again, you have 21 days to appeal, 14 days to apply for a court-appointed lawyer. What about the money? When can you pay the money? I can give you.
Judge, he does have a bond of $750.
Yeah. So he's not discharged. I'm trying to remember that rule again. The new rule. I think that the court keeps it 10%. I think the court keeps it. So you have 675 to apply. And then I'll be glad to set you up on a payment plan.
Your Honor, I will take care of that today, sir.
All right, I wish you well. I really do.
Your Honor, is that balance 1210?
So after the 675, he's gonna have 1210. Okay,
Today we come back.
thank you. Have a good day. Good luck, sir. We'll see you by 1. Albert Rocker, Persephus, Delvendale, Gab, Ward, 26W84303. You have to unmute. All right, tell me your name.
My name is Ward.
I need your name again. I didn't, you have to state your name again.
My father. I said Ward.
Why the connection is so bad? Tell me your name again.
My name is Persephus Ward.
Okay, good. That was a good connection. Now listen to me very carefully. You're charged with littering from a motor vehicle. You have the right to a lawyer. If you want one, I'll give you one. You want a lawyer?
No. I just voted guilt. I did it, you know.
Go ahead and
admitted
arraign you,
to
and
it,
I'll send you to the
know.
prosecutor. It is alleged that you did operate a motor vehicle on I-75 southbound or west in Woodhaven at 3:57 in the morning on May the 24th of 26. And they think you were littering. That is a misdemeanor punishable by up to 500 fines, 90 days jail, costs, and all those. You understand that?
You said what?
You understand what I said? They think you were littering from a motor vehicle on that date. They think you threw a tissue out the window. They pulled you over. They charged you with littering. These are the possible penalties. I didn't say they were going to happen. It is punishable by up to 500 fines, 90 days jail, costs are all those. Do you understand that?
Yes, I can hear you now.
Did you understand what I said, sir?
So now you 90-day jail, and then you said I was
Do this like this. You're
break
gonna
up.
have to go
I'm trying to
somewhere
hear you.
else in the future. Listen to me very carefully. I can't do this. I'm not picking you up. You're not hearing me. I don't know where you're gonna go. I don't need you to fly to Detroit, but I'm not gonna have you in the same location because it's not working. Wherever you are, when we reschedule the court date, you're gonna have to move to a different location. I don't care where it is. I don't know what to tell you, but I cannot pick you up. I cannot hear you. You cannot hear me. So I'm simply going to adjourn this, Heather. We'll adjourn this. We'll set a new arraignment pretrial date. And you're gonna have to be in a different location and you're gonna have to know how to show up. Do we understand one another? Of course we don't, because you can't hear me. Heather, chat with him. Give me a new date, please.
Okay, do you want to just do the Monday, July 13th at 1 o'clock?
Fine, July 13th at 1. Chat with him and tell him that, okay?
Okay,
He's gonna have to be in a different location, I think. I don't know where he is, but we can't pick him up. Thank you. Samantha Jean Height, 26W841554. Come on up to the podium. Destiny Henry, you're gonna be next. Where'd you get districts on next 5 then?
Yeah, it's up.
Huh?
It's up there.
Your name, ma'am? You're charged with the violation of criminal responsibility law. You have the right to a lawyer. Would you like one?
Yeah.
On May 29 or 26, they think that you did the offense of retail fraud by failing to ensure the regular attendance of your child, Emmett Height at Woodhaven Upper Elementary School at 24825 Hall Road in Woodhaven. That is a misdemeanor punishable By up to 500 fines, 90 days jail, costs are all those. Do you understand that? Yes?
Yes,
Did you sign, read, and understand the advice of rights form?
yes, that's right.
If you plead guilty, you'll be giving up all those rights, and we're not going to have a hearing or a trial. Do you understand that? You still wish to waive your right to a lawyer. I'm entering a not guilty plea, $500 personal bond. You cannot leave the state without the consent of the court or violate any law. You must appear in court as directed. You're to ensure the regular attendance of your child. I realize this is summer.
Yes, sir.
Maybe the child isn't in school now, but if this somehow pushes out, you're to make sure that child attends school. You understand that?
Yes, sir.
All right, any questions? All right, good luck. She's gonna take that file to the prosecutor. Sadie, I'm in, Mr. Zone.
Who, Heights one prosecutor?
Yes, she's representing herself.
Just have a seat in the hall.
Did we ever get that,
Now.
okay. Still waiting the blood results, Mr.
They're in there, Judge.
They are?
Yeah, they told me they were in there. And apparently they were hidden. I'm sorry to speak with Judge.
Let me see. Are they in the pre-sentence report?
Might be there too, Judge. But it was in the file. They found it after I left here that Monday.
Oh, they did? People against Purnell Lamar Fountain, 26B150239A and C. Let me check. I ran,
I didn't bring my reading glasses either, so
that's all right. I ran through this real quick this morning. I didn't see them in here, but let me find them.
I know that after I left here, they probably said in the file, come back, but he was on his way back to Toledo, and he's on Zoom this morning, Your Honor.
Okay, sir, your name?
Purnell Fountain.
Judge Edward Zelmack for the defendant. I appreciate you allowing me to have him appear by Zoom at the last moment. He's from Toledo. We've had 2 false starts on sentence, and he has a family emergency this morning.
That's fine.
I think, Mr. Fountain, what was your blood alcohol level, Mr. Fountain?
I believe it was like a 0.14, I believe.
That was a blood draw, Judge.
All it says is that in the complaints, and they didn't do,
It drew blood.
I know, but as of April the 23rd, the Brownstown Police Department still didn't have them. They were still pending. So then we took the plea on the 22nd. Sadie, go see if she said so that. So I had her get a hold of them this morning. I don't want to make a bigger deal of this than it is, but I still want to know for sure it sounds like that was the PBT result. So let me just double check and make sure we have them. She said she was going to send them.
So I was, thank you.
Oh, you're fine. Stay right there. Let me see. I think that she should be
Ms.
coming
Foley's
back.
not here today because she remembers too, because she called me as I got in the car, but it was too late.
Who's here for Brownstown today?
Miss Foley's here, she would know because,
Oh, she's here?
why, I don't know, she's always here. though.
Yeah, I thought you said she
Do you want me
was.
to call the conference room and see if she's in there, Judge?
Yeah, and ask her to come in here.
Okay,
I don't have them either, but I saw the results because they called me when he was charged and she sent him a correspondence.
Okay. All right.
I know it wasn't that high.
Well,
I mean, that is high, I'm sorry, but when I started.
No, but I get it.
15 was something.
I get it. Here they are. So I don't need her. He had THC in his blood. I don't even see where they have a. Call in the prosecutor, will you?
she's on her way over to you right now, Judge. I got a hold of her.
Thank you. All right, so let's just wait for her and we'll go from there. They didn't send me any report other than saying he had THC in his system.
Shall I have a seat, Judge?
No, you're good. Just wait right there if you would. It won't take. Miss Foley Carter, your name?
Caitlin Foley, Carter, Roslyn Township.
I took it to drive a plea to operating while impaired. It was due to the consumption of alcohol. I've been trying to get the blood results from Brownstown. They sent the packet over. I only see where he had THC in his system.
Your Honor, it looks like he had alcohol of 0.149 grams.
Is that, well, all they sent was the supplemental reports. This report was completed, it looks like on April 13th. So I don't have an original report regarding alcohol. Do you have that?
Your Honor, I did also send it over to the court after this was adjourned.
Okay. All right, good enough. So, yeah, if you could just give me a copy for the file, that's fine. All right, Mr. Fountain, I'm sorry about the confusion here. State your name again, please.
Purnell Fountain.
Mr. Zelnick, have you reviewed this report with him, and are there any material additions, corrections, or deletions?
None at all, Your Honor.
And for the record, she's handing me this report. It does say 0149. So go ahead. I'm sorry.
I'm delighted that my client has a better memory than I do.
Right.
Your Honor, I see nothing, this is a true first offense, I see nothing else to add. He's in Ohio and he said he's prepared to come, once his mother squared off, perhaps tomorrow to pay the fines and costs and full and arrange with probation, if you would allow him to come meet with probation tomorrow. Is that correct, Mr. Fountain?
Yes.
That's assuming you don't incarcerate him.
No, I got it.
So he'll be here tomorrow to complete the matter in the court recalls. He was here twice. Once I was out of town, once we couldn't find the blood results. So I apologize.
How
This
far,
time he couldn't make it.
how far is Holland from here? Is it outside of Toledo?
Yes, sir.
So it's about an hour, is that right?
Little over an hour, about hour and 10 minutes.
All right, good enough. Is there anything you would like to say, sir? You're all set.
Thank you, Your Honor.
Thank you.
No,
Anything
sir.
you- All right, I'm gonna place you on probation. I'll adopt this report, 12 months. You can leave the state, can leave state without consent. You live in Ohio. You cannot violate any law or ordinance if you change your address, place of employment or home telephone number. You do have to notify probation. No alcohol, no marijuana, no illegal drugs. You're not to purchase, possess, or consume one of those. You're to submit to chemical testing, PBTs and ETGs monthly or more on demand of probation. Kratom poppy seeds and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. I do want you to attend the Victims Impact Panel. I do want you to attend the Substance Abuse Group through Class A Training Center. I'm not gonna make you come here for the court work program. I'm gonna let you do 4 days jail credit, 1 serve 3, and I'll let you do those by way of community service. And I'm gonna give you until August the 15th to complete 24 hours of community service. You can do that at any nonprofit organization of your choosing, okay?
Yes, sir.
Fines are 300, cost 200, 75 victims' rights fee, $50 justice assessment, 6 1/4, screening fee 60 for 685. Probation fees are 240 for a total of 925, and you have cost of recovery of 218 for a total of $1,143. If you violate, your probation could be revoked. You could be incarcerated for 93 days. You have 21 days to appeal. You have 14 days to apply for a court-appointed lawyer for purposes of appeal. You may be eligible for early discharge. You get everything done, no violations within the preceding 90 days by statute. You are entitled to early discharge. So you can make a petition after 6 months. So sometime around Christmas, okay?
Yes, sir.
All right, so I think I'm gonna just say pay by tomorrow. Is that, you can pay it in full by tomorrow? Is that what he said?
You can pay that by tomorrow in full, is that correct?
I don't know if I'll be able to pay it in full, but I will be able to get a big chunk of that taken care of tomorrow. But I know I'll for sure I'll have it all the way paid next Friday when I get my check. Absolutely.
You know, Steve, what's the big?
Listen, I'm just gonna give you until a week from Monday to pay it in full. You gonna be able to do that?
Yes, sir.
So I'll make that, let's see, and that will be on the, what day is that? July 6th. You just pay in full by July 6th. You better check over there. I don't know if, I'm sure they've got people that are gonna be there tomorrow. But I want to make sure he's not sitting around either. On the defective equipment, fines and costs are $120, okay? So $120 on that. And I'll say pay that by July 6th. If you need more time, no problem. Call the court. We'll go on Zoom. I'll give you an extension, okay?
Yes, sir.
All right. I wish you well. Thank you,
Thank
Mr.
you,
Zellman.
Mr. Fountain.
Thank
Good
you.
luck with your mother today. Please bring a big chunk when you come here tomorrow. I'll check with probation.
All right. Have a good day.
Thanks
a lot. Thank you very much. All right. Is Destiny Henry here? Destiny Danier Henry.
You want to go over the victim?
Pardon me?
You want me to go over the victim?
Not yet.
Okay.
Your name? All right, you were in front of me and I ordered you not to have any contact with the victim as part of your bond conditions that I entered on May the 27th. And I have here in front of me a charge that alleges that you failed to refrain from having contact, direct or indirect, with Michelle Newsom. If I find you didn't have contact, you'll be exonerated. If I find you did have contact, that is, you either called her, wrote her, saw her, texted her, emailed her, phoned her, I don't care what, any one of those scenarios, then you could have your bond could be forfeited, the relief revoked, and a new bond set. Do you understand that? Do you have a lawyer representing you on this case?
Carmen. He's on.
Did you speak to Mr. Carmen today? My apologies.
He is out there.
I'm gonna need him in here. Why don't you have a seat at the table right behind you? Sean Eric McKenzie. 25F243230. Your name?
John McKenzie,
Why'd you wait so long to take care of this?
to be totally honest, I don't know, what this is the for. I'm here for another matter.
You got a ticket for impeding traffic back in January of 25. It was out of flat. They think you were operating on West Huron River Drive.
Yeah.
Hang on. Went into default. We show caused you. Didn't show up for that. Back in May of 25, I issued a bench warrant, May the 20th, 25. Then it looks like you came in here on May the 20th of 26. We canceled the warrant and you must have posted the bond. Is that what happened?
Yes, yes, sir.
Why didn't you show up on this? Don't tell me you forgot. I forgets. Why didn't you show up?
I tend to avoid situations like this, because I have to call off work and my work isn't, exactly understanding the.
That's a reason. It's not a good reason,
I understand.
but it is a reason. Not one I'm gonna buy. Okay? Heather, does he still owe $237?
272 is his balance.
Have another 35 with you?
Okay.
Trying to pay $265 total. Balance is waived. I trust that I jumped the gun here a little bit. I trust that the bond is in his name, right?
Let me take a look. Yes, it is. He has a bond of 237.
Good. You add another 28 on your credit card and that'll take care of it. Good luck. Have a good day. Go down and deal with them. Stop doing that. It's not a good idea. Thank you. Destiny Danier Henry, sorry. 26W842-495. Come on up again, ma'am, and state your name. I didn't realize you had a lawyer already, Mr. Carmen.
Michael A. Carmen, 734, South Defendant Ground.
So I just explained the charge to her. My apologies. I didn't realize you were on this. For failure to refrain from having contact, direct or indirect, with Michelle Newsom. And ma'am, and I did explain to her that if I find she had contact, I could revoke her release, forfeit her bond, and set a high cash bond. And that is the charge. And I'm asking you at this point, how does she wish to proceed? Does she want a hearing or does she wish to plead guilty?
She's gonna plead not guilty, and we ask for a hearing, which should be very quick and simple.
Okay, let's call in, the Woodhaven prosecutor and let's get the victim in here. And you can have a seat right behind you, man. Is Albaraki yours? Which ones do you have? You got Mr. Patrick, right?
Yes, I have that. 113 is here. Who's mine?
All right.
Who?
Jeremy Allen Schultz, 23W830846. Your name?
Jeremy Allen Schultz.
All right, so you just, met with prosecutor and you are going to plead guilty to attempted retail fraud, correct?
Yes, sir.
So it says older case, defendant since charged has numerous multiple jail sentences.
Yes, Your Honor.
Your appearance?
William Burke on behalf of the people of the city of Woodhaven. I discussed this matter at some length with Mr. Schultz. He has served jail sentences in Eaton County, Macomb County, Oakland County. He suggests, although I wasn't able to confirm myself, that he did attempt some pleas by mail over the course of time. He has retained Jeffrey Puda for other matters. He came to this court indicating he wished to represent himself. And so the people felt that the ends of justice would be met by an attempt to plea.
And that's fine. I wasn't actually calling you in on this one.
Oh,
But you said, and you don't have any objection to a suspended sentence.
affirmative.
But you didn't agree to that.
No objection to a suspended sentence, but it's not a killaboo plea, if you will.
It just, you're just telling me I don't have any objection if the court just imposes fines and costs.
Affirmative.
But there's no sentence agreement between you.
No.
So do you understand I can go along with that, but I don't have to go along with that?
Yes, sir.
And you understand that this is punishable by up to $250 in fines, 45 days jail, costs are all those?
Yes, sir.
And did you sign, read, and understand the advice of rights?
Yes, sir.
If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you
Yes, sir.
understand that? You still have the right to a lawyer. If you want to change your mind, I'll be happy to provide you with one at public expense. Do you
No, sir.
understand that? You still wish to waive your right to a lawyer?
Yes, sir.
Anybody forced you to do that?
No,
The charge attempted retail fraud, how do you plead?
guilty.
On May 17 of 23 at 8:29 a.m., where it blows at 21,000 West Road in the city of Woodhaven.
Yes, I was.
And did you take out some kind of a mower, ego mower, it says, while in the store and walk past the register without paying for it?
Yes, I did.
And was that valued at $649?
Yes, sir.
Anybody forced you to plead guilty?
No.
Are you on probation or parole?
Yes, I am on probation.
Were you on probation on May 17 of 23?
No, I was not.
All right. I'm gonna accept your plea to attempt retail fraud, dismiss the retail fraud. I'm going to still order a pre-sentence report. I want to get everything, I want to know a little bit more about this pre-sentence report, sentence date. I already told you the bond conditions. We'll give them a sentence date. Heather,
We can do this one on, how about July 22nd at 8:30?
July 22nd at 8:30, okay? So you're gonna go down the hall, they're gonna give you your paper notice, then you're going to go over to probation where you'll be interviewed. Any questions?
No, sir.
Okay, good luck to you. Thank you. Now, this is the one I was actually calling you in on. Destiny Danier Henry, 26W842495. I'd like the victim in here. I have arraigned, Mr. Carmen, your name again?
Michael A. Carmen, P 7384, that's the defendant, Your Honor.
Ma'am, your name?
This man.
And ma'am, your name
Michelle Newsom,
and your appearances?
Jessica O'Donnell on behalf of probation.
William, you're gonna have the people working.
So Mr. Carmen has advised me that his client wishes to have a hearing. So I'm going to go ahead and swear in the victim as well as Ms. O'Donnell. And we'll go from there. Both of you, raise your right hands, please. Do you solemnly swear affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole truth, so help you God? Ms. O'Donnell?
Yes, sir.
Ms. Newsom? All right. John, why don't you take that garbage can over there for her, please? I'm gonna ask you to throw your gum in there, please. All right. I don't care how we start. You can go ahead and start.
Because I have one bond violation I issued on June 22nd. My one bond violation is failed to refrain from having any contact, direct or indirect, with Michelle Newsom. I was contacted not only by the victim, but by the detective on the case for Woodhaven PD regarding that Destiny, Miss Henry, had contacted the victim via text message. The text message is from an iCloud account that I do have, that I do know is Miss Henry's account, because she communicates with me through that account. It looks like she sent a text message to the victim, Miss Newsom, June 21st. There's only one text message that was received. The text message relates to Miss Henry's child. It states that her son will be with me all July 4th weekend. That is the one text message. According to this, the no contact form states that she's not had any contact with her except through their family court proceedings. As of right now, there's no family court order in place. They have a hearing scheduled for July. The only court order that's in place, to my understanding, is regarding a Judge Hessen case. Miss Henry is also on probation with Judge Hessen for a domestic violence case. In that no contact order, Judge Hessen issued a no contact order stating that she's not having any contact with her son's father, who is Jason Haney, who is the victim's son. It also states that the no contact order is to include their child custody should be done through third parties, meaning that Destiny's parents should be communicating with Miss Newsom and keep the parents out of the situation, that it's just the grandparents that should be communicating regarding the child's custody agreement. That's why I issued the violation regarding this.
I'm sorry, I'm a little confused about the relationships with everybody here.
Yes. So Miss Henry has a child with Jason Haney. They have a son together. Miss Newsom is the mother to Jason Haney. So she's the mother, she's the grandmother to Miss Henry's son.
All right. And the content of that was the child will be with me.
July 4th, yeah.
July 4th.
That was the text message that was received. It was regarding her child. But again, as far as I'm aware, the no contact order states that they're only to be communicating through third parties.
If I may, Judge,
Yes.
grandmother, so to speak, is the victim in the stalking case that is before this office.
That is correct.
Do you have any questions of Ms. O'Donnell, Mr. Kerman?
I would just ask, I believe you already said Ms. O'Donnell, but there's one sole text message at issue.
That was the only one that I received from the victim. That's correct.
And it states, I believe, Deborah will be with me all July 4th weekend.
That's correct. It is regarding her child.
Said this was June 21st,
I'm sorry, let me double check. June 21st, it's
at 12:34 p.m.
yes.
No further questions.
Do you want to add anything, Ms. Newsom? I issued this bond, entered the bond, I should say. Issued the bond on May the 27th. Is that the only contact that you've had?
Since that hearing, yes. Before, tons.
Right,
Since the hearing, just that.
okay. Do you have any other questions, any other testimony, anything you'd like to say, ma'am?
I just want her to follow orders. Me and her mother is doing communication for custody. I do not want any contact with her.
Anything else?
Your Honor, I would ask Ms. Newsom, Deborah is my client's son, correct?
Correct.
And your son's son?
Yes.
Again, there's currently a proceedings for child custody in the Wayne County Circuit Court
Correct.
and just involving Deborah. Correct.
Yeah.
Okay, thank you.
Does your client wish to testify?
No.
All right, any argument at all?
Motion? If he does not wish to testify, Your Honor.
Any argument anybody have?
Your Honor, I would simply indicate that, I believe the court was clear. There is a highly functioning relationship between the two grandmothers. The other grandmother is in the back pew, if you could raise your hand.
Okay.
So the communication is highly effective to uphold any, what if any, parenting time the young lady wishes. She violated a court order. There was no reason, because there's no breach of communication between these two grandmothers. In essence, Judge, at least as far as looking after Devereaux, these two grandmothers are on the same team and they have his best interest at heart. The whole reason for being in court on this matter was the stalking for this young lady. So I believe this does beyond or by the standard of proof before the court for this, which is not guilty on a reasonable doubt. I believe it does constitute a violation, and I would ask the court to make such a finding and leave any sanction to the court's obvious discretion.
Your Honor, this is actually very simple. It's being made out to be more complicated than it needs to be. My client does have an ongoing case with Judge Heston. That's dealt with in the other courtroom. As far as in your courtroom, Your Honor, on the bond sheet, but you specifically wrote, with an exception to the no contact order, it's a little difficult to read the handwriting specifically, but I believe that it says, except in conjunction with custody proceedings in circuit.
In conjunction with circuit court proceedings.
Circuit court proceedings.
I think what I meant was, I know what I meant, is that if she runs into her in the circuit court, that's not gonna be deemed a violation of the no contact. If there's something that happened in the order, I don't know exactly what the circuit court order was. Does the circuit court order provide for any kind of contact?
No, my son had told the circuit court that I did not want any contact with her because of prior instances that I was willing to mediate for him since they couldn't do the mediation because of prior charges. So he said that I'm willing to speak with her mother and do communication exchanges. She agreed, and that's just how that.
Look, there is no question that you violated the no contact provision. You had no right to go direct her. No, I'm not gonna violate your bond and lock you up for this, but I'm gonna caution you. There's not to be any contact at all with Ms. Newsom. Do you understand that? Yes? I can't hear you. I find that you violated the no contact provision. You had no business having direct contact with her. So I'm telling you, if it happens again, I'm not going to hesitate to set a high bond. And you'll be sitting in jail awaiting trial on this. Do you fully and completely understand? I can't hear you.
So Your Honor, just for clarity, just for what you wrote on the bond sheet there.
Yeah, it says, except in conjunction with circuit court proceedings. This has nothing to do with a circuit court proceeding.
Well, I mean, my client indicated that to me it did because they had a circuit court proceeding scheduled on July 13th. She was just, I mean, it's custody, it's visitation.
But she's not a party to the circuit court proceeding. Miss Newsom here is not a party to that.
But my client has indicated was that she's very involved.
It might, well, because I was saying, I know if I didn't say except in conjunction, except to effectuate visitation or custodial exchange with minor children. I did not say that. What I was saying with my except in conjunction with circuit court proceedings If she goes and she's there, I'm not gonna have somebody come in here and say, she violated the no contact. She showed up, she was there, and the defendant was there. That's all I was trying to clarify.
I understand, and that's the clarification I was seeking.
I understand. But this young lady knew that. And I'm telling you, you're playing with fire. Do you understand what I'm telling you? I can't hear you. All right, so are you guys, I'm gonna find that there was a violation. I'm not gonna change the bond. I'll continue the bond. Are you guys going to go and try to pre-try this?
Yes, sir.
All right, good enough. That's what I'll do. And when you come back in front of me, maybe you're soft-spoken. We gotta pick you up. You gotta have your voice about 40 times the decibel level that you have it now, okay? Thank you very much.
Thank you.
Thank you. Are you ready on Patrick, or do you want me to go on to something else? It's up to you.
Say it again.
You want me to do Patrick, or you want to go on to something else?
We can do Patrick. He's great.
This is a tough one. I'm just gonna be honest with you. Accepting him, but I'm likely to send him to jail. I just want to know, I want you to know that.
A routine traffic hearing turned into a heated debate over a school bus safety violation. Police testified that the driver passed a school bus after its lights changed from yellow to red, insisting he had plenty of time to stop. The driver disagreed, explaining that when he reached the front of the bus, the lights were still yellow, and stopping suddenly could have created a dangerous situation. As both sides presented their arguments, the judge carefully examined the facts and the law. In a surprising ending, the judge ruled the driver not guilty, finding that he made a reasonable safety judgment under the circumstances.
In this courtroom, the judge carefully listened to every detail before reaching a decision. The court showed patience, fairness, and respect for both sides, while ensuring that accountability remained at the center of justice. The judge's words reflected the importance of responsibility, self-control, and respect for others. Rather than acting on emotion, the court relied on facts, evidence, and the rule of law. This case serves as a reminder that justice is not only about punishment, but also about protecting victims, encouraging accountability, and maintaining public trust. The courtroom once again demonstrated why fairness and law matter in society,